is sometimes referred internationally, your claims have an inventive status. They're not obvious to those skilled in the technology. Okay? So that's what the examiner has determined when a patent grant issues. Yes, Eve?
I've heard people talk about a difference between the U.S. and other countries and one being first to file and the other being first to invent. Can you explain that?
Yes. The U.S. is the only country in the world that has a first to invent system. Every other country in the world has a first to file. First to file is easier to explain. The person who gets to the patent office first, files their application first, they have the right to the patent, okay? As long as they're an inventor. If they stole the invention from you and then raced to the patent office, no. Theft doesn't get you a patent, or at least it doesn't get you a patent that you're going to be able to keep. First to invent is basically operates on the premise that the person who invented it first, regardless of who arrived at the patent office first, gets the patent grant. Okay? Gets the patent grant. Now, in terms of practical matters, most of the time the examiner's operating on your filing date. Why? Because we don't know when you invented it. We don't even know when you brought it to us. If we come up with prior art that occurred less than 1 year before you filed it, you have the opportunity to prove that you invented it before that document was published. Okay? You have the opportunity to prove it. How do you prove it? Well, you don't prove it with the mailing the envelope to yourself. That won't work. You prove it with notarized, corroborated documents, lab notebooks that have been signed by multiple parties, etc. All of those can be used to establish that you invented it earlier. Okay? Very few applications ever face that. Okay? Very few. In my experience, it was less than 10%, closer to about 5% during examination. Even fewer, it becomes a dispute between two parties that believe that they're entitled to the same patent, the same U.S. patent. Very few end up in what we call an interference, where two parties believe they're entitled to the U.S. patent. So it doesn't come up that often. So first to file is usually what the default examiner is using in the U.S., even though our law has first to invent.
Hello? Country. So, for example, somebody who's already filed for a patent in the United States and Canada, could someone else in Germany go and file? They'd be the first to file in Germany. But I just don't know whether, they look around the world at first to file anywhere or just within their country.
It's actually not as easy to explain, because what happens is that they generally look within their country, but they look within their country based on applications that can come in from other countries. There's an international treaty called the Paris Convention that entitles inventors in any country that's a member of the Paris Convention to file in their home country and then file anywhere else in the world that's a member of the Paris Convention and get benefit in that other country of their first filing in their home country, as if they filed it in those other countries on the date that they filed it in their home country.
And that's for a 12-month period?
And that's, well, they have 12 months to exercise that Paris Convention right. So, yes, each country only looks at what's filed when they're evaluated. They will look at publications. So if there's a publication that's out there, they'll look at the publication. And because most countries now publish at 18 months, they'll have access to those as documents to serve as prior art and evidence of lack of novelty.
So let's say we take Germany as an example. If somebody applied for a patent in the United States and the 12 months went by and they never applied for a patent in Germany, can a competitor go in Germany then and apply for a patent
countries require, in order to get a patent, that the person has a legal right to it. How do you get a legal right? Well, either you're the inventor or you have the rights assigned to you from the inventor. Okay, so if an applicant files here in the United States, let's say files a provisional, never files a non-provisional, never files anywhere else in the world, they just give up. Can an inventor who invents it independently file for protection in Germany? The answer is yes. Okay, the answer is yes. But can they talk to the inventor, realize that's a valuable invention, and then go and file in Germany? The answer is legally no. They didn't invent. They didn't have the assigned rights from the inventor. So the answer is legally no. Now, does that happen? I hate to say it, theft occurs. Theft occurs, and yes, occasionally a company or an applicant for patent gets a patent that they're not entitled to because they either didn't invent it or they didn't have the legal rights from the inventor. Okay? And there are mechanisms, every country has their own mechanisms to repair that situation. It's unfortunate that that happens, but every country does have mechanisms to deal with that. Most of them are judicial.